Um, when there is a major situation at a building, as an example, fire, flood, who is responsible for housing the tenants? And could renters insurance help them with that?
Yes, it could help them with that, but it is very specific to the policy that they purchase, which the landlord won't be involved with. And it's essentially the same as saying when something bad happens, hey, tenant, call your mom. Because you don't know what that is. You don't know what that relationship is. You don't know what's involved there. And you're just kind of crossing your fingers and hoping that someone takes your problem off your hands. Because at the end of the day, the landlord is going to be expected to reimburse for housing costs. And reimbursement happens a couple of different ways. Reimbursement is expected. And then if it turns out that it's the tenant's fault, that usually isn't discovered right away. And so sometimes a landlord puts out money because there's this obligation to house, there's this obligation to find alternative housing, and the courts will assume that any problem that is caused in a house is caused outside of anybody's control, maybe by a third party, maybe by a negligence issues, maybe just by some sort of internal fault or electrical system issue. The assumption is never going to be that your tenant fell asleep on the couch while smoking a cigarette. It's never going to be that. And so a lot of burden is placed upon landlords to find alternative housing, but a tenant has to pay for it. A landlord can reimburse them. And then if later on it's determined that the tenant was responsible, some of those amounts that are paid can be sought back. But normally at that point, you're already looking at court. You're already looking at submitting those costs to your insurance. And those insurance policies usually have a provision that says, if you're submitting this to insurance, let's back up a little bit. Let's assume that there's a big fire and the house and the property's gone. That's an insurance claim. You're going to be submitting all sorts of stuff on that insurance claim. When you do that, most policies say that any amount that is due from another party because of their fault, the insurance company, by paying you, gets the right to go after that person. You don't get the right. Let's imagine that it's a much smaller issue, like the tenant backed up their toilet and they have sewage all over the property. So that might not actually be an insurance claim. That might just be you contact a plumber, you get cleaners out there, and it doesn't justify the deductible that you might have to pay for an insurance claim. In that situation, you would coordinate with the tenant to reimburse for alternative housing, probably offer either a mutual termination or say, hey, the property is ready to move back in, move back in. And if they refuse to do so, now you have a situation on your hands where you're probably going to involve an attorney anyways, or you just wash your hands of the whole thing and you say, I'm just going to mark this as a loss and move on to my next tenant. And that's generally how it works in the real world. If you end up with a huge bill, it's insurance. If you end up with a small bill, then it's usually a matter of, is it worth hiring an attorney, or is this cost just not quite enough to justify that? And then you end up with this sort of weird zone in the middle where it's a lot, but it's not quite enough. And that's when you should have somebody who does this for a living. Maybe Ayla would be a good contact. You might have an attorney who you could reach out to for at least a consultation to say, is this worth it? Or you might have the experience yourself to say, oh yeah, I'm not going to go after this. So sorry, I can't be more clear on that, but that's pretty much how it goes.
No, that makes a lot of sense. And that kind of segues into kind of our section, and we're jumping around slightly, but around maintenance. So, in a situation, where you have, let's use the example that there's a leak, it's not habitable, and you need to place a tenant. I've heard situations where part of the issue that made it uninhabitable was that the tenant did not disclose the leak, and now you have mold in the apartment. So can you walk us through how would you address that situation? I mean, yes, the landlord has to make the unit habitable again, but part of the reason it's gone so far was lack of disclosure from a tenant.
So there's a couple of statutes that would be directly on point. And this is another provision that I recommend being in a lease. It's not absolutely required, but I recommend it, which is to set a time period in which tenants must advise of certain types of damage to the unit, specifically water damage. And I usually recommend that in writing, the tenant is required to notify you within 24 hours of there being a leak or standing water or other issue. That's very helpful for me later on. And so if it's not clear from maybe my tone or maybe the implication of what I'm saying is this situation tends to be one that ends up in court a lot, which means that there's no easy answer. And it depends a lot on the personalities of both the tenant and the tenant's family and the landlord at the time that this crazy thing is happening. Sometimes people aren't at their best during these emergencies and they do dumb things or they make strange calls or they say terrible things to their landlord that they just refuse to take back. So, in those situations, it's helpful to have a lease clause that defines when they're supposed to tell you, because then you can say there's a minimum requirement on the tenant to advise of damage. Statutes exist to say that a tenant is required to give notice to a landlord in writing of certain types of violations. And if they don't, then there's the implication that they have waived any remedies because they didn't give any notice. Mold, however, I should flag this. I wish we had a big red flag to put in it. Mold is the source of one of the most infamous cases in the last 10 years, which is Guildford versus Widener. And if you guys feel like reading some very dry legal stuff that has a couple of snippets of some like telenovela storylines in it, that's a good case. It's also a good case that I was going to talk about later on, but if we don't get to it, just know it exists. There's a couple of different versions of it out there. The idea is mold happens, tenant doesn't move out, tenant then has medical issues. What happens? What happens is about 8 years straight of litigation and all the litigation costs that come with it. If you guys haven't been through litigation before, and this is real litigation, this isn't like small claims. Real litigation is anywhere from $25,000 to $50,000 per year every year until it finishes. Some years it could be more, some years it could be slightly less. But imagine 8 years of that. So that's what Widener went through. Almost certainly that's what it cost them. I wasn't involved for the 8 years, but the case has been on my radar for a long time because it's had multiple Supreme Court appeals. So imagine the idea that you go all the way through trial about mold, and then all of a sudden you go to the Supreme Court, and the Supreme Court says, do it again. So you go back to court, and then you get a result, and it goes back to the Supreme Court. The Supreme Court comes back and says, you didn't get it quite right. And so now, 8 years later on, that's mold. If you have a situation with mold, here's what I say. Mutual termination. Get the tenant out, fix the situation up so you can put a new tenant in, and then deal with the finances later on. If your tenant will not agree to a mutual termination, you need to be able to make a determination that the unit is not habitable so that you don't put the tenant back in. That involves having an appraiser or someone or inspector come out to make that call. It might be good to tell that inspector what you'd like the report to say. Because if the inspector knows that you are concerned about mold, they might be able to give it a little bit more attention. And if their report says that it's not habitable currently and it needs remediation, it gives you reason underneath the statutes to terminate a lease. So anyways, we're very technical. Some of this doesn't really apply. And if you have something like this, here's what I recommend. Talk to an attorney. Talk to an attorney right away. Okay, sorry to take you off path there. That's a crazy case. It's a crazy situation. And it's one of those weird stepping, like dip your toes into the broad arena of actual litigation.
I appreciate that, Brian. And what I took from that is, address the situation in a fair, reasonable manner very quickly. And, take your tenants' concerns about this seriously as well. So I know some landlords like to disregard this concept of mold and saying, oh, it's probably just mildew. But in some cases, it could be, and that might get somebody in trouble.
Yeah, a couple of real world recommendations. So best practices is to get people in a situation if there's mold is to get your maintenance crew, is to get somebody who's doing this stuff to go into the unit, arrange a time to come in with a tenant and take photographs of the area where it might be existing so that you can establish a photographic timeline of what is existent, what it looks like, and what things might be happening. And photos are going to do you a world of good, especially if you date them, you keep them in the client file, or you have a dashboard system where you can organize that. That's best practice. If it looks like a legitimate issue, like there might be some plumbing or some leaking issues, there is good reason to get the tenant to make arrangements for a plumber or other inspector to come in and take a look. It's probably worth the price for that. And then if the plumber comes in and says there's nothing, then you can kind of continue on. If the tenant complains again, I'd call that tenant a trouble tenant and I'd try to terminate that lease. Mutual terminations are completely allowed. Mutual terminations are essentially a new contract that replaces the lease that says, by mutual agreement, this lease will now terminate at this agreed date. Both parties sign it. That document, that lease termination, that mutual termination, then becomes adequate grounds to evict that person if they don't move out by that date and time. It's a wonderful tool.
That's fantastic. And since we're on the topic of maintenance, one question we get a lot is talking about what is a timely manner. Now, I guess you could define that in the
Yeah.
lease, but talking about obviously some maintenance is an emergency and right away. But let's talk about like general maintenance and then emergency maintenance. What's a timely manner that judges like to see if you're ever in front of court?
So this is going to depend. I don't know how many people we have here who have units outside of Anchorage, but just know that reasonable time to repair is completely different if you're away from a population center, if you're away from Anchorage, Wasilla Palmer, or Soldotna area. If you are outside of those areas or Juneau, um, the reasonable time period is going to be vastly different, especially if it's something that takes some sort of specialist or some sort of repair or some sort of shipping is involved. So just be mindful that reasonable is very fact dependent and each situation is going to be unique. And so in Anchorage, generally, the idea is that you would be, as a landlord, upon receiving notice that there's something going on, you should be able to show email correspondence that you've talked with the tenant, you've confirmed that they've communicated with you, and that you're in the process of arranging for either maintenance or that you're having a contractor come out there and you're waiting for the contractor to schedule things. If that's all happening within, depending on the severity of the issue, within 24 to 72 hours, you're probably good. If you wait a week, it can get pretty dicey. But I've also seen a week be okay. So it's really judge dependent. If you have questions, you can talk to an attorney, but frankly, sooner is better. If you are an out of town or an out of state property owner who's managing remotely, it's good to have somebody who's boots on the ground, or at least just be very prompt in your communication with your tenants. I see a question up on the side here.
Does it help to have a mold addendum?
I've not seen a great mold addendum ever. I've seen mold addendums that try to be good, and I've never really had an opportunity to litigate one in court. Because I recommend all my clients never get to court with a mold issue. Mold is just it's it's too there's too much potential for it to spiral out of control in the court system. If somebody has a mold issue and they ask for a jury trial, I am telling my client to spend money to get out from underneath that case and try to settle by handing over thousands of dollars and get out from underneath it. That's what I'm advising.
Mm.
It's just too dangerous. And so a mold addendum, sure, that might help. Can I tell you that it will help? No, I can't tell you that it will help.
Mm. Good answer. So going back to kind of like the timely manner and whatnot, what happens if a landlord does not reasonably respond to the repairs or complete repairs? What are some of the tenant's recourse?
Okay, we got to pull up some statutes here real quick. So where's my stuff? So we have a couple of different things that we should be aware of. When a are you guys, well, I shouldn't ask that because I don't have a video camera on everybody. There's a series of statutes that everybody should know exist, and that's going to be the Landlord Tenant Act. In that Landlord Tenant Act, there's going to be one of those statute numbers that talks about specifically the tenant obligations. There's going to be another statute number that talks about the landlord obligations. And if something doesn't fit perfectly within that landlord obligations or tenant obligations, you might have to be a little bit creative in your reading. And if it completely doesn't fit, then it's not covered. So when a tenant is asking for something to be fixed, sometimes I'll back up. Generally, best practice is try to fix that thing. If it's something that was one way when they moved in and now it's another thing, odds are you should fix it. If it is very insane, if it's outside of that realm of kind of a reasonable thing has changed in their tenancy and they're asking you to fix it, if it's outside of something that you've ever heard of or seen before, like maybe the sink is gone. Okay, that's insane. So what happens there? Okay, well, that's not reasonable. And so you have to find out what's going on. In most of those situations, the best thing to do is to fix the issue, track your cost and expenses, and then give them a 10-day notice for reimbursement. And that works really well because then you've got them on something that's extremely trackable. You've got a troubled tenant who something crazy happened. And now, instead of having a violation for doing some random crazy thing that makes everybody think they're on an episode of Cops or Judge Judy, instead, we're in a bookkeeper's office and we're saying, here's a receipt or a reimbursement request for $1,500. Did you pay $1,500? Oh, no, you didn't. So, okay, you didn't cure. You breached. It's much cleaner. And so, when you can, if there's something that's very clearly into the realm of that's not the landlord's responsibility, you can still do the thing. You can just then keep track of your expenses and submit it for reimbursement. You can do that on the ledger, but it works really, really well as a 10-day notice for violation of a lease. If you have a lease clause that says that repairs and other fees or cost would be additional rent, that works extremely well. Again, one of my recommended clauses in a lease, but doesn't necessarily need to happen.